Good morning, everybody. A very warm welcome to the last in our series on bills of lading and time charters. This is the last in our time charter series, but hopefully you've enjoyed the series, and I'm pleased to say we'll be running a series on voyage charters and then cargo claims. So I do hope you will join us for those. I will, as usual, start with a few notices. So we are still working from home, sadly. I hope that I don't have to keep saying this message in the next year or so. So please bear with us if the dogs bark, the letterbox goes, or you hear children running around. And no doubt you are in a similar position. We have a marketing team on hand to help with any technical issues, so please use the chat function on the system. The session is being recorded and will be available to view in the next few days. Together with the slides, you'll be sent the details for that. And it also appears on our YouTube channel. A feedback form will appear at the end of the webinar. Please do fill those in. We do appreciate your time and your feedback. I think that is all the notices. So let me kick off with this last seminar. Hang on. So you've just seen the short video about the firm. For those of you who have not been on one of these webinars yet, we're a full service law firm, as you'll have seen, with offices in London, Cambridge, Chelmsford, Ipswich and Norwich. And we do all the things you might expect of a full service law firm, plus quite a few niche expertise areas that you might not expect necessarily. One of those areas is shipping and international trade. Here is the team. I am Alex Davey, I'm a partner, and my colleague Sarah Holsgrove will be doing this seminar with me. As you'll have appreciated, our webinars and events are on our website. And as I mentioned just a moment ago, we have a YouTube channel where you can actually see all of these, this time charter series and other webinars if you want to at your own leisure. So this session is on bills of lading and time charters, particularly the interrelationship between bills of lading and time charters. Now, clearly, bills of lading is a huge topic in itself. We could probably have a series on that and go into a lot of detail. So this is really an introduction and a talk about that interrelationship with time charters. We'll be looking at what is a bill of lading, what are they for, and look in detail at the three functions of a bill of lading. We'll also look at identifying the parties and title to sue. So I hope you can see this. This is the front page of a standard bill of lading. This is actually the Congen bill, but all bills of lading will have similar look to them and similar wording. And I just wanted to take everyone through what we've got here. So we obviously have a number of boxes to fill in, the details of the shipper, the consignee. In this one, we have the notify address, or can be the notify party. It's worth saying that is a really confusing, sometimes really confuses people who the notify party is. This is the person that the ship contacts when the ship arrives and is ready to discharge cargo. It is nothing more than that. Please don't think that the notify party is a party to the bill of lading. It can confuse people. Then we have details of the vessel, port of loading, port of discharge. Then there's a box here for the shipper's description of the goods. Now, this is a charter party bill of lading, so I'll explain what that is in a minute, but you'll see here it says freight payable as per charter party dated. So in theory, a date should go in here to date the charter party so you can identify it. But Sarah will explain to you what happens. Often that box is not filled in and what you do in those circumstances. Then you've got some important boxes down the bottom here, the place and date of issue of the bill of lading, the number of originals, which will be 3, and then the freight payable at, And then finally a signature box, another really important box to look in. You'll be really focusing on who has signed that bill of lading. And then it's worth just looking at some of this wording here, which is, again, you will find is pretty much standard on lots of bills of lading. So it says here, shipped at the port of loading in apparent good order and condition on board the vessel for carriage to the port of discharge, or so near thereto as they may safely get the goods specified above. And the important wording in there in particular is in apparent good order and condition. And we'll look at what that wording means. And then again, some really important wording here: weight, measure, quantity, quality, condition, contents, and value unknown. And we'll look at, what does that wording mean. And then finally, in witness whereof the master or agent of the said vessel has signed the number of bills of lading indicated below, all of this tenor and date, any one of which being accomplished, the others shall be void. So there are 3 of these, and we'll look at what that wording means in terms of any one being accomplished, the others shall be void. So that's a fairly standard front page. And then if I show you some back pages, so this is the back page of a Congen bill, actually a 2007 bill. You'll see that because it's to use with charter parties, so the terms will actually come from a charter party. There are very few terms on the back here. The particularly important bit here is all terms and conditions, liberties and exceptions of the charter party, dated as overleaf. If you remember, I said it had to be dated. It was meant to be dated on the other side to identify that charter party, including the law and arbitration clause, dispute resolution clause, are herewith incorporated. We'll look at what that wording means. If you've got a liner bill, and if you're in the liner world, then quite often, in fact, the terms will all be on the back or in teeny tiny type, and probably much more accessible on a website somewhere. This is the Conline bill, I think, but basically a liner bill has all the terms on the back, so slightly different. So having just identified what exactly we're looking at, what are the classic 3 functions of the bill of lading? What are these bills of lading for? So it's believed that they started the bills of lading started in the 14th century as a non-negotiable receipt. So the merchant would turn up with their goods and hand them over to a ship, but they wouldn't travel with the goods themselves. So it's a non-negotiable receipt identifying the type and quantity of the cargo and the condition in which it's been received, because the merchant's going to say, I handed over really good cargo, and the buyer at the other end wants that receipt to confirm that. At some stage later, the parties decided that this receipt would be a good place to put in some terms of a contract of carriage. And so the second function, sorry, catch up with myself, is evidence of a contract of carriage. And we'll explain, we're not saying it's a contract of carriage, we're saying it's evidence of a contract of carriage. We'll explain that again shortly. And then finally, perhaps the clever bit is a document of title. Merchants wanted to sell goods before they reached their destination. And so the bill of lading became a document that one could hand over. It's been called the keys to the warehouse. So effectively, you could sell the keys to the warehouse. Whilst the vessel was traveling, the cargo could be sold multiple times by transfer of the bill of lading. So those are the classic 3 functions of a bill of lading. So just to speak a little bit more about that use in international trade. If I go back if you have a look at our very first webinar, I had this diagram, and I explained this diagram. If you have a look on our YouTube channel, you can watch that. But basically, what I was doing here was explaining that, this is just an example, but a seller would sell goods to a buyer and then sell them on to another buyer, which we'd call the receiver. And the buyer in this example was organizing the ship. So you've got a ship with a head owner who's chartered it to a charterer and subchartered it and then subchartered it to the buyer. And what I was explaining in this diagram is that as well as these charter party contracts and these sale contracts, you also have a bill of lading. So that bill of lading, that receipt and the evidence of a contract of carriage is issued to the shipper, the seller, by the carrier. And the clever bit is that that becomes a document of title. So in this example, the buyer opens a letter of credit with the bank and says to the bank, if the seller gives me all the relevant documents, the inspection certificates, the commercial invoice, and the bill of lading, then please pay the seller the money. And in that way, the buyer and the seller are both protected. So here we go. So the bill of lading now transfers to the buyer. The seller's been paid, and the buyer now has control of that cargo. And then let's imagine that the same thing happens with the receiver. So we've got another letter of credit and a bill of lading. So now the receiver has the bill of lading. And when the ship turns up at the discharge port, the receiver can then present the bill of lading to the carrier, whoever the carrier is in this example, and say, please, can you give me my cargo? So that's the clever bit about the bill of lading. Now I have to go back to my slide. Bear with me. A word about international conventions. What happened with bills of lading is that they were initially a carrier would carry cargo under strict liability. So if they lost the cargo, they were strictly liable unless they could, you say it was act of God. So they were strictly liable. Then when contract terms started to be negotiated, carriers would put in lots and lots of limits and exclusions, and the shippers and insurers, cargo insurers obviously argued about that. And ultimately domestic legislation in many countries was introduced to try to regulate the bargaining power between the shippers and the carriers. And that led eventually to the Hague Rules in 1924, an international convention that various countries could sign up to, that everybody was following the same set of rules. Subsequently, they were updated by the Hague-Visby Rules in the 1960s, and then there was subsequently the Hamburg Rules, which were adopted by some countries, but it's fair to say the Hague-Visby Rules are still much more widely used than the Hamburg Rules. And then, of course, some of you will be aware the Rotterdam Rules were drafted in the 2000s, but as at today, still haven't had enough signatories to come into force. So as far as English law is concerned, Hague-Visby rules were adopted by the UK under the Carriage of Goods by Sea Act 1971. But this is the important bit. If you are looking at a bill of lading that is subject to English law, that doesn't automatically mean that the Hague-Visby rules apply, because the Hague-Visby rules have their own applicability regime. So you have to look at the Hague-Visby rules, which say that they only apply if the cargo is, well, one, loaded from a contracting state, or the bill of lading is issued in a Hague-Visby country in a contracting state, or the parties have contractually agreed that the Hague-Visby rules are incorporated. If either of those three situations apply, the Hague-Visby rules are compulsorily applicable. So English law bill of lading, cargo from a Hague-Visby country, bill of lading issued in a Hague-Visby country, then compulsorily applicable, or if they're contractually agreed. If not, then it is a matter of contract as to what the parties have agreed. They may have agreed Hague-Visby applies anyway, but they may also have agreed something else. And I've put at the bottom there, because a lot of bills of lading, the parties will agree the Hague Rules. and they will say the Hague Rules apply, but they'll also say that only Articles 1 to 8 of the Hague Rules apply. And you might have wondered why that was. And the answer is this. The Hague Rules have a limit of liability of £100 per package, which is obviously not very much. But they were drafted in 1924 and they have a gold standard. So Article 9 of the Hague Rules says that actually that £100 should be converted into in modern day currency. So it's £100 worth of gold in 1924, and it's whatever that is worth today. And so what you have to look is at the gold value and compare it to and work out what £100 worth of gold in 1924 would be today. And it will, depending on how much gold is worth, often be more a much higher limit. Now, if you only incorporate Articles 1 to 8 and you do not have Article 9, you don't have the gold standard, and in theory, you therefore have a limit of liability of £100 per package. And that is why people incorporate only Articles 1 to 8 of the Hague Rules. I hope that is helpful. So, let's look at the first function of the Bill of Lading, and then I'll let Sarah take you through the other elements of the functions. So it's a receipt. It's an important record of what was loaded, and as you'll have appreciated, that is likely to be used by the bank. It could well be used in financing arrangements. And it's very important because often the sale contract will require the seller to present and effectively sell the cargo on loading at the ship. So it's a really important record of what has actually happened at that moment in time, how much cargo has been loaded, and what quality it is. And the carrier is responsible for the accuracy and honesty on those bills of lading as a matter of common law. And not only that, of course, the carrier needs to make sure this is an accurate document, because when they arrive at the discharge port and the receiver says, please, can I have my cargo? If they cannot give the cargo in the correct condition and in the correct quantity, then they're likely to face a cargo claim. And this is reinforced if you have the Hague-Visby Rules or the Hague Rules. So Article 3 says, after receiving the goods into his charge, the carrier or the master shall issue to the shipper a bill of lading showing, among other things, and if you look down there, the apparent order and condition of the goods. And then if I just jump to 3.4, such a bill of lading shall be prima facie evidence of the receipt by the carrier of the goods as therein described. Proof to the contrary shall not be admissible when the bill of lading has been transferred to a third party acting in good faith. So what that means is, let's say, for example, you're loading steel coils and they're rusty. If the bill of lading does not represent that they are rusty, when a receiver, a third party acting in good faith, says, please, can I have my steel coils that I've bought, and they turn out to be rusty, the carrier can't at that stage say, but they were loaded rusty. That's where the master should clause, or the owner should clause, the bills of lading. So that's make remarks on the bills of lading, commenting on the condition of the cargo. Now, you'll appreciate that the master is then under considerable pressure to sign clean bills of lading. If the master makes remarks on the bills of lading saying there's a problem with the cargo, the chances are that the sale, that the financing will fall through, and that the sale itself might fall through. So there can be a real tussle at the load port between a master who wants to clause the bills of lading, or is worried about clausing the bills of lading, and the charterers and the shipper who want a clean bill of lading. And the question, the courts have said that the test for deciding if a cargo is in apparent good order and condition is a reasonable person with reasonable eyesight. So the master does not need to go and get independent expert evidence as to whether or not the cargo is in good condition or not. It is simply the reasonable person with reasonable eyesight. Now, it quite often happens that a shipper or charterer may say, I will offer you a letter of indemnity. You sign a clean bill of lading and I will give you an indemnity, so that if somebody then says that there's a problem with this cargo, I will indemnify you. Now, if there's a genuine dispute about the condition and whether or not the bills should be claused, that might be okay. It might be okay. But the general rule is that as a matter of English law, that is seen as a fraud on the buyer, because the buyer has no idea that this debate has gone on and doesn't know the condition of the cargo. And at the English courts and the English law system treats that as a potential fraud on the buyer, and therefore says that those letters of indemnity are unenforceable. Now, in some countries, the letters of indemnity will be enforceable, but under English law, they would not. And I think the only other thing I was going to say on this is that quite often you get off-hire disputes because parties are trying to determine what the terms of the bill of lading should be. And as I say, it does become a bit of a tussle between the various parties involved because of the importance of getting this document correct as a receipt. I'm now going to hand over to my colleague Sarah Holsgrove, who's just going to talk about the second function of bills of lading.
Thank you, Alex. Let me just check I can move these slides over. Brilliant. So the second function of a bill of lading, as Alex has mentioned, is that it is evidence of the contract of carriage. Now, the precise legal theory behind this is a little complicated because bills of lading are not normally issued until after the cargo has been loaded. However, in reality, it's very unlikely that any shipper would be entitled to or would ship goods onto a vessel unless the contract of carriage had already been agreed. One point to note is that the terms on the bill of lading do not represent the contract of carriage itself, where the shipper or receiver is also the voyage charterer for the specific vessel carrying the goods. In that case, it is the voyage charter party that is the contract of carriage. In the hands of any subsequent holder of the bill of lading, so that's anyone the bill has been transferred to, the bill of lading is the contract of carriage. The fact that such a contract exists between two parties who may not even be aware of each other is unique in English law. And in a 1936 case, Lord Atkins commented that a new contract appears to spring up between the ship and the consignee on the terms of the bill of lading. Some bills of lading contain a detailed set of terms and conditions which govern the carriage contract. However, charter party bills of lading, such as the Congen bill which Alex showed you a few slides ago, are specifically designed to incorporate charter party terms. And that's the case even though a third party endorsee of the bill may have never seen those terms. The problem is, of course, that some charter party terms are specifically designed to govern only the charter party relationship. So that's the relationship between an owner and a charterer, as opposed to this shipper-receiver relationship. Therefore, for charter party terms to be incorporated into a bill of lading, particular criteria must be met. The first of these is that the words incorporating the charter party must clearly and specifically describe the terms to be incorporated. So words such as all terms, conditions, and exceptions of the charter party dated X will incorporate only those terms which are relevant to the shipment, carriage, and discharge of cargo and payment of freight. On the other hand, words such as terms of the charter party would not necessarily incorporate the exclusion clauses. Another point to note is that the charter party clause to be incorporated must also be consistent with other clauses in the bill of lading. Now, the courts are prepared to allow for some verbal manipulation here, for example, in cases where a clause has been expressly incorporated by the bill of lading. However, words such as the charterer shall pay demurrage, as an example, are unlikely to read as meaning that the bill of lading holder shall pay demurrage. There's also been a lot of dispute in particular about law and arbitration clauses. Whilst a law clause in the charter party might be construed as an indication that the parties have agreed a particular law, arbitration clauses, on the other hand, need to be specifically incorporated. general words of incorporation will not be sufficient, unless, of course, the child party itself specifies that arbitration will apply to a bill of lading disputes. It's common to find that the parties have failed to identify the child party which is being incorporated, and this is what Alex mentioned earlier, that little box is often blank. Now, where there is more than one time charter party, the presumption is that it is the head charter party which is incorporated, as this is the one which is likely to involve the owners, who are the carriers under the bill of lading. However, if one of the charters in the chain is a voyage charter, then it's likely to be the voyage charter which is incorporated, and that was decided in a case called the Nan Free. Now, if you've got a very rare set of facts where you've got multiple voyage charters, which does happen from time to time, it is the head voyage charter that is likely to be incorporated. Now, the reason is because a time charter is a contract for services, so its terms are much less likely to be relevant compared to a voyage charter, which is a contract for carriage. The same principle applies with a carrier under the bill of lading as a charterer. Where a voyage charter displaces a time charter, this can create real practical difficulties because it is possible that neither the cargo receivers nor the carriers will have a copy of the relevant charter party terms, and in reality, they will probably never have seen it. For that reason, it's common to see owners impose strict clauses setting out the terms of bills of lading that they are prepared to sign or authorise. If you like, they're trying to protect their position. If such a clause does not exist, then the master is obliged to sign the bills as presented, even if they increase the owner's liability. But a master is not obliged to sign any bills of lading which contain extraordinary terms or terms which are manifestly inconsistent with the charter. So some examples of that might be, if your bill of lading names a disport outside the charter trading limits, the master does not have to sign that. If a bill of lading incorporates a clause, a bill of lading does not incorporate a clause required by the charter, and the master wouldn't have to sign that. If a bill misrepresents the quantity or condition of the cargo, the master wouldn't have to sign it. That would be a fraud, as Alex has mentioned. If a bill doesn't conform with the mate's receipts, again, master doesn't have to sign it. And if a bill has an incorrect date, and some of you may have come across antedated bills, the master doesn't have to sign it. But a master is not entitled to refuse to sign a bill because it contains a foreign jurisdiction clause or a clause that's marked freight prepaid. He's also not entitled to require the bill of lading to incorporate a lien clause. So whilst a master does have some choice, it's not a complete free rein. See, I can go on to the next slide. Oh, didn't realise these were going to jump in, so apologies. There we are. These slides will be available on YouTube if people want to look back. So the third function of the bill of lading is the document of title. Now, the bill of lading has on its face a space identifying the consignee. Now, this is the party to whom delivery of the goods is to be made. And hopefully you will have seen that when Alex had the Congen bill on the side at the outset. However, a bill of lading will not simply name a party, and that would make life too easy for all of us. It will instead say, for example, to order of X or assigns, and that would be an order bill, or the space will simply be left blank, in which case it will say to order or assigns, and that would be a bearer bill. This wording means that although the carrier is expecting to deliver to one party, the bill can be transferred to a third party without any involvement of the carrier, so that the goods have to be delivered to that third party. For a bearer bill, all that is required is to physically hand over the document. For an order bill, the named consignee must endorse the bill, and generally you may have seen that this is by affixing a mark to the back, a stamp or a signature in some way. And in that mark, stamp, signature, they will either identify the endorsee or they will endorse in blank, in which case the bill can be transferred like a bearer bill. As mentioned a few moments ago, this is a unique characteristic of a bill of lading under English law. Not only does the endorsee obtain a right to possession of the goods, but under the Carriage of Goods by Sea Act 1992, the endorsement of the bill of lading will transfer all rights and liabilities under the contract of carriage. Now, the consignee's right under a bill of lading is the right to demand possession of the goods. This is what Alex mentioned as the key to the warehouse. It does not necessarily pass on ownership in the goods unless that was the intention of the parties. And you probably find that the moment when ownership passes is dealt with in the sale contract. A straight bill or a seaway bill is a document of title which is either expressed to be non-negotiable or where there is a named consignee. Now, such a bill cannot be transferred. But nevertheless, for the purposes of the Hague-Bisbee rules and also Cogs in 1971, a straight bill is held to be a bill of lading or a document of title. The carrier is obliged to deliver the goods only against presentation of the bill of lading. If he doesn't do so, the holder of the bill of lading can sue him for misdelivery of the goods. This is the case even if the owner has delivered the goods to the named consignee or even to the owner of the goods. In both situations, the bill of lading may well have been pledged to the bank by way of security, and the bank's possessory rights prevail over proprietary ones. The carrier therefore must always take great care to ensure that he is delivering to the correct party. Although bills of lading are issued in 3 sets of originals, the carrier will have a good defence to a misdelivery claim by virtue of having delivered the goods against one of the original bills, provided the carrier has no notice of a problem. And as Alex explained at the outset, the bills state on their face that if one is accomplished, the others will be void. A carrier may commonly be ordered by a time charterer to deliver without presentation of a bill of lading, and many of you will have come across this issue. Now, unless the charter party specifically allows this, such an order is unlawful and the owner is not obliged to obey it. And the owner is also entitled to take time to make inquiries as to whether the order is lawful. In addition, P&I clubs will not insure against the risks of delivering without production of a bill of lading. Therefore, if the owner decides, or perhaps is obliged by the terms of the charter party to follow the charterer's orders, he should demand a letter of indemnity from the charterers. It's worth bearing in mind, however, that any letter of indemnity is only as good as the person giving it. Now, in terms of whether an owner is obliged to follow the charterer's orders in this respect, it's important to read the terms of the charter party closely. If it says that the owners may deliver, then there's still a choice and investigations can be made. If it says they must deliver, even then, if there is doubt, they don't have to deliver. Now, a letter of indemnity for issuing a clean bill, as mentioned by Alex, is likely a fraud and unenforceable. However, the type of letter of indemnity I've just mentioned, so that's a letter of indemnity for delivery without the original bills of lading, are not a fraud, and it's important not to confuse those 2 points. A letter of indemnity for delivering without the original bill of lading is covering an owner when they have no P&I cover. Now, cargo claims, and in the general sense, are a very, very wide topic, and we will in due course be producing another webinar series exclusively on cargo claims. So for the purpose of this webinar, I'm just going to talk about the headline points and in terms of identifying the parties with title to sue and who to sue. Now, generally speaking, where there is a problem with goods on discharge, it's essential that the cargo interests identify the correct parties to any legal claim. So they must establish who has title to sue and who can be sued. If cargo interests get this wrong, it's highly likely that any claim against the correct party will end up time-barred, and they may also be required to pay the legal costs for the wrong party. And as you may well be aware, under a bill of lading, there is generally a 1-year time-bar clause, so there is quite a tight time frame to get this right. Now, in terms of who to sue, the issues involved in identifying the contractual carrier were very complicated and confused until the House of Lords took the opportunity of clarifying the law in 2003 in a case called the Star Sin. The basic rule is now to look at the face of the bill of lading, and hopefully there is one on your screen. If the front of the bill identifies who the carrier is, then this is binding. However, the logo of a shipping line is not conclusive and may well be irrelevant, so it's best not to be confused by that. If it doesn't state who the carrier is on the face, then the next step is to look at the signature box. So this is down in the bottom right-hand corner. If this is signed by the master or for and on behalf of the master by agents, then the carrier is likely to be the master's employers. So that means the registered owners or the demise charterers. This means it will be an owner's bill. If an agent signs without actual authority, so if the terms of the bill do not conform to the authority in the charter party, for example, then the agents are still likely to have apparent authority to bind the owners. If the charterers or agents do not sign as agents, then they may be deemed to be the carriers themselves. In many cases, a charterer will do this deliberately. They may do it to promote a marketing brand or to protect customer information. You often see that with freight forwarders. or they also do it in the case of container groupage or through transport. In such cases, the shipping line may issue a master bill to the NVOCC, so that's the non-vessel owning carrier, and the NVOCC will issue a house bill to its customer. If there is ambiguity, then written or typed amendments will override standard printed clauses, and the courts will try to give effect to all of the terms of the bill. Therefore, it's always worth checking the reverse of the bill for an identity of carrier and demise clause, which seek to make the owners the carriers, despite any indications on the front. However, these are probably only relevant where there is ambiguity. If the bill is a charterer's bill, the owners of the vessels could still be liable in tort, so that's not contract law. That's because the ship owners become bailees for reward of the cargo and owe the cargo interest a duty of care. A bailment can be on terms, the terms being the terms of the bill of lading contract, and in addition, the owners may be able to rely on the exclusions included in any Himalaya clause protecting the servants or agents of the carrier. However, such a clause will not include the jurisdiction provisions. It's worth bearing in mind that these complications do not exist in many other jurisdictions where the claimant can sue both the owners and the charterers. So, who is the claimant? Unlike normal contract law, in order to make a claim under the bill of lading, the claimant does not need to be the party that owned the goods at the time of the loss, the party with risk, or the named consignee. The identity of the claimant is determined by looking at the Carriage of Goods by Sea Act 1992, which I'll refer to from now on as COGSA 1992, because that's quite a mouthful. COGSA 92 applies where English law is the putative proper law of the contract. It applies to both bills of lading and seaway bills. Now, bills of lading in this context include received for shipment bills, to order bills, and bearer bills. And seaway bills include straight bills and pure seaway bills. So that's documents that are stated to be seaway bills on their face. Now, a party can only acquire rights and liabilities under a bill of lading if he's the lawful holder. Under a bill of lading, the original party's rights and liabilities under the bill are extinguished when a third party becomes the lawful holder. Note, however, that the original party's rights outside the bill, so under a charter party where the shipper is also the charterer under a CIF sale, remain intact. So who is the lawful holder? I've put section 2.1 of COGSA 92 on the slide. This section sets out the person with title to under a bill of lading is the lawful holder. And on the next slide, please don't worry about trying to read all of this, I've put section 5.2 of COGSA 92. This explains that the lawful holder is the party who has physical possession of the bill, is the named consignee or ultimate endorsee, and is a holder in good faith. So that means not by theft or mistake. Now, the reason I put those two chunky bits of text on your screen is that COGSA 92 contains various provisions about other parties, but those really are for another day. COGSA 92 is probably one of the most complex English acts, and probably the most complex I've had to consider, and it's extremely difficult to follow, so it's best not to get bogged down in it unless you really have to, and I've put it up there just to give you an example of what it looks like. So if the lawful holder of the bill is not the owner of the goods, then the holder of the bill may not have suffered any loss in the event that the cargo is damaged. However, pursuant to section 2.4, the lawful holder can bring a claim on behalf of the party who has incurred the loss or damage, but they would have to hold any damages recovered on trust for that party. So that's why the lawful holder need not have property or ownership of the goods, ultimately, or even at the time of the loss. In the event of cargo damage, the lawful holder is not obliged to bring such a claim, but such an obligation may arise under the relevant sale contract. Alternatively, the party who has suffered the loss or damage may be able to bring a claim in tort or bailment, as discussed a few moments ago. And also, as discussed earlier in this webinar, where the parties to a bill of lading, so that's both the carrier and the consignee or the ultimate endorsee, are identical to the parties to a charter party covering the same shipment, the bill is deemed to be a mere receipt and does not amount to a contract of carriage. In such circumstances, no claim can be brought under the bill and must be brought under the charter party. Note that only the named charterer can bring a claim under a charter party, and even then, only if he has suffered the loss and the goods were at his risk when the loss or damage occurred. Although a claim in tort may appear to be slightly simpler than a claim against the carrier, Under the Bill of Lading, in order to make such a claim, the claimant must own the goods or be entitled to immediate possession at the time they are lost or damaged. It will not be enough if the goods were at the risk of the party at the time of payment. Now, title normally passes under a CIF sale contract at the time of payment, save where there is a retention of title clause. Be aware that in continental jurisdictions, if a cargo insurer has paid on a claim, they must make a claim in their own name, so that's as assignees of cargo interest rights, whereas in the UK, an insurer generally has a subrogated interest and will sue in the name of the assured. So as discussed a few moments ago, cargo claims entitled to sue are a complex area, and we will in due course be presenting a webinar series on that topic. Now that brings to an end our slides. We do have time for a question session, and some of you have very kindly submitted questions in advance. So perhaps we'll tackle those, and whilst we're tackling those, if you have any questions, please feel free to use the question box, which I believe appears on the right-hand side of your screen. If you type into there, and you can see me looking to the left, if your questions appear in that box, we will do our best to answer them. But looking at the questions that a couple of you kindly submitted in advance, the first one, which I may hand over to you, Alex, while I read the other questions that are coming in, is a question about switch bills and an explanation of how switch bills work. So if you don't mind taking that, please, Alex.
Yeah, thanks, Sarah. Happy to. Yeah, so someone's asked about switch bills. First of all, what is a switch bill? Basically, what this is about protecting confidential commercial information. So a party will be a signatory to a switch bill and maybe the consignee, and then once they have the bills of lading, they will hand them back to the carrier and say, please could you now issue some new bills showing me as the shipper and a new party as the consignee. And that effectively prevents the original shipper knowing who the final consignee might be, and just, as I say, protects that middle person. Now, they're potentially problematic because, as you appreciate, we're issuing bills that have new details of who the shippers are, sometimes potentially even different. People try to put different loading ports in and so on, and so they're slightly problematic, but I believe they're widely used. They're very common in the industry. And the key thing, I think, for a carrier to be aware of in relation to switch bills is clearly you'd never issue new bills of lading without having all the originals back. The last thing you want, last thing any carrier wants, is lots of bills of lading in the world, and people presenting bills of lading and saying, "Please, can I have my cargo?" and not knowing which ones are the legitimate ones. So, if you're a carrier and you're asked to issue switch bills, then you definitely want the 3 originals back in first.
Brilliant. Thank you, Alex. There's 2 more questions come up here, so I will try to deal with those. The next one is a question, if I've understood correctly, about endorsements, and where you've got multiple endorsements on the reverse of a bill of lading, how do you work out who has title to sue? I'm smiling because this is something that I frequently have to grapple with, and I think the question is really when you look at a reverse of the bill of lading, so where you've got all of the terms and conditions on the back, and the face of the bill says to order of X or to order of X or assigns, and what has happened is there are then multiple stamps on the back. Maybe the shipper, maybe the first person named as the consignee, there may be banks in there, and you've got a whole chain muddled all over the back, and it's trying to work out who is the ultimate endorsee and who has title to sue. The short answer is there is no quick solution. What you have to do is try and piece it through, and I often end up numbering them. So I look at the front, work out who was first, try and identify who they went to. So if they've put, Joe Bloggs assigns to Fred Smith, then you know Fred Smith is second. Then you can try and find Fred Smith's endorsement, see who he endorsed it to. If they haven't endorsed it in blank, that makes it trickier. And in that situation, you probably need to try and get hold of the sale contracts, because if you can get hold of the sale contracts, you can piece it together. And the other thing, of course, that you can do is if you've got a party saying, I do have title to sue, then if they can prove that they had the original bills of lading and they handed those over for receipt or delivery of the cargo, then there's a good chance that they have title to sue. But it is a tricky one, and it can take some time to try to piece together where you have got multiple endorsements. I can just see another question that's popped up here. I'll just have a look at this.
Yeah, it's just a question about, yeah, it's a question about ship carrying an original bills of lading on board the vessel. That's a good question. Any views? I think, to my mind, that the problem, and I'm sure you'd agree, is that it kind of defeats the whole object, because obviously the ship is meant to arrive at the discharge port. Somebody is presenting a bill of lading. In return for that original bill of lading, they are then delivering the cargo, and they're protected hopefully from any misdelivery claims because they're delivering to the correct person. By carrying the original bills on board the vessel, the question then is, well, who are you then meant to hand those original bills to when you arrive at the discharge port? Now, I suppose if the whole exercise is because you know exactly who the parties are and there's not really any debate, and maybe the original bills are straight bills as well, perhaps the risk is lower. But certainly I would be initially concerned that it defeats the whole object of the exercise. I mean, of course, there is often a problem that original bills don't arrive at the discharge port by the time the ship does. It's exactly why we had Sarah was explaining about letters of indemnity for delivering without original bills. But the solution of carrying them on the ship might not be great in many circumstances. I hope that answers that.
Now, there's another one here about demise charters, and I can see another one's just popped up. So, Alex, if I take the demise charter question, if you can possibly just be reading the one that's just come in. So, someone's asked, what's the relevance of a demise charter when bringing a cargo claim under a bill? So, demise charters are something that give lawyers for cargo claimants a bit of a headache. And the reason being that you might be able to identify who has title to sue, who your cargo interest is, and you may have a bill that is signed for and on behalf of the master, so you'll be confident that it's an owner's bill. Now, obviously, we can all go on the internet and work out who the vessel belongs to, and in a large number of cases, they will be the carrier. The problem is where there is a demise charter or a bareboat charter, because where there is a bareboat charter in place, the party that the claim needs to be brought against is the bareboat charterer. But you won't find out about that demise charter or bareboat charter on Google. The only way you'll find out is by asking the carrier. And that's why more often than not, when you get security for a cargo claim from a carrier, or where you are seeking a time extension for the 1-year time bar, the cargo interest will ask the carrier's representatives to warrant and confirm that there was no demise charter in place. So the simple answer is, if there's a demise charter, then the claim needs to be brought against the demise charterer as carrier. So it's very important to try and get confirmation that there is no demise charter, otherwise you run a risk of time barring a cargo claim. So that's the relevance of a demise charter in a cargo claim context. Alex, any others there that you want to, or we've got time to pick up?
Yeah, I'm going to pick up one question. Somebody's asked about the liabilities of shippers and receivers, because we've talked a lot about liability of the ship and potential for cargo claims if cargo isn't delivered as set out in the bill of lading. But it's worth remembering that the shipper potentially has a residual liability, and the receiver could potentially have a liability. And what could that liability be for? Well, first and foremost, dangerous cargo. So if there's dangerous cargo loaded on board, the shipper could well find themselves liable. Similarly, if there's a call for general average, then the parties to the bill of lading will be asked to provide general average security and maybe to contribute to general average. And then finally, on liner bills, there'll be key rent and demurrage payable on the boxes. And if those cargoes are abandoned, which sadly happens, then the shippers and receivers could well find themselves, well, certainly potentially both of them could find themselves jointly liable for those sums. For a consignee, as Sarah mentioned, under COGSA 92, once the consignee demands or takes delivery of the goods, the obligations under the bill of lading contract transferred to them.
Brilliant. Well, unless anyone else pings any questions through in the next few seconds, and none have come up, that draws to a close this webinar and also this webinar series. So this is the last webinar in our Time Charter series. As Alex mentioned at the outset, all of these webinars are available on YouTube. The slides are there. You will also be emailed the slides for this webinar and a recording. We will be, as I said at the outset, running more webinars. We'll be doing voyage charters and cargo claims in due course, although we're all going to take a little bit of a break now over the summer and probably come back to you in the autumn. So thank you again to all of you for joining us. I know many of you have attended all of these webinars, so thank you for that support. It's gratefully received. And please do fill in any feedback forms. If there's anything you'd like us to cover in future webinars, please put it in there. Now's the time to help us shape the next series. And thank you again. And we look forward to seeing you in the autumn.
Thank you very much.